everyone. Welcome back to the second session on geographical indicators. Today we'll be discussing. We had first session on our for the yesterday where we discussed about the concepts of a GI. We looked into what essentially constitutes a GI. What is the thread behind establishment of a particular branch of IP, which is again a communal in nature. So in this particular session, we'll be looking at India's law. So we'll be covering Indian Act, and we'll be looking at how and what can be protected. What are the major GIs being protected? What is the process of protection? What are the rights conferred and the duration of protection? With that, let's move on to the session. Okay. So we covered all these features of GI and international scenario in the last session. For this session, we'll focus exclusively on the Indian scenario. In India, the GI is protected under the Geographical Indications of Goods Registration and Protection Act 1999. Though the act was enacted in 1999, it only came to force in 15th September 2003. So these dates are important for, especially in perspective of your net examinations. So the GI Act was enacted in 1999 but came into force only in 2003. This particular act is divided into 9 chapters with 87 sections, and it was also being complemented by the Geographical Indication of Goods Registration and Protection Rules, which came into force in 2003. So the authority established under the GI Act is the authority registrar of geographical indicators under Section 3 of the Act. Though there is a separate authority called the Registrar of Geographical Indicators, basically the Controller General of Patents, Designs and Trademarks act as the registrar of a GI. So, though there is an established separate registry for the GI, it is actually been handled on by the Controller General of Patent, Designs and Trademark. The definition of GI, we in the last class we looked into what actually is a GI. We looked into various definitions, what is constituted as a GI under the general consensus and international consensus. In this specific Today we'll be specifically looking at India's definition. The concept of GI, or what constitute a GI, or what is eligible to be called a GI, is defined under Section 2E of the GI Act 1999. As per the Act, GI is specifically applicable to basically three types of goods. One is agricultural goods, second is natural goods, and third, it is for manufactured goods. So either you have a agriculture goods product, say for example, we were talking about tirur beetle leaves and all. So tirur beetle leaf is an agricultural goods. Then there is a natural good, specifically whatever we get from the specific region that is naturally occurring there and all. And then we have manufactured goods like the Aramula Kannadi and all, which is a manufactured good. So, as per the Act, only three kinds of goods are being protected. One is agricultural good, natural goods, and the manufactured goods. Another condition that is coextensive with the definition under the Act is that it should be originating or manufactured in the territory of a country or region or locality. So, this particular theme that it has to originate or manufacture in a particular territory uh, is seen in almost every definitions of GI. What makes GI different from other forms of protection or other types of IP protection is that it is due to those particular origin that it gets these specific qualifications. So it is very important for the jog indication to have some connections with the place where it originates. So it should be originating from here or should be manufactured in this particular territory. And due to that specific condition, because it has originated or manufactured in this particular space, it has a given quality, reputation or other characteristics of such goods. So it is, because it is originating from a specific area, it should have some kind of quality or reputation or other characteristics. So these two things are at most importance in while understanding GI. Also, when you're talking about manufactured goods, the Act further clarifies that the definition clause, especially Section 2E, further clarifies that when you're talking about manufactured goods, then the production or process or preparation of the good should happen in that specific area. Any of these process, it is not really necessary to have the unique origin or any particular ingredient to be from that area. It is only necessary to have the production at that place, or the process is happening at that place, or preparation is happening at that place. So that is a specific extra qualification for manufactured goods. So basically, according to 2E, geographical indicators the indications would be given to three types of goods, in namely agricultural goods, natural goods, or manufactured goods, provided it originates or manufactured in a specific territory, and due to that specific origin, it has a quality or a reputation or other characteristics that is associated with this origin. And especially when we come into this into looking into manufactured goods, then these either the production or processing or preparation should happen in that particular area. So that is what basically a GI's definition is covered under the Act. Let's look into what is so what basically happens is that any product which satisfies these qualifications can be registered as a GI. But then there are Section 9 of the Act further says that some things are not registrable. So as when we look into the Act, they have listed out seven um, categories where the indications become non-registrable. So the first category is that the particular indication is likely to cause a confusion or deceive someone. So it has been confused with an existing mark or an existing popular well-known mark or something like that. So if there is some kind of um, dependence or some kind of confusion that's likely to happen, then that particular GI indication cannot be registered. If it's contrary to law, then it cannot be registered. If it's obscene or has scandalous matter, then it cannot be registered. Or it is likely to hurt religious sentiments, it is again not registrable. Otherwise, disentitled to protection. If it's already been said that it is not eligible for protection by any court, then again this is not registrable. And again, generic names or indication of goods are again not registrable. Also false representation is also something. So I caught the last one says that though it is true to a territory or region, but is falsely represented to a person that the goods originates in another territory. So it has been produced in a particular say for example in a district, in a particular place in Thrissur district, but then it has been advertised as it is coming from some other place. Even so, that misrepresentation is also makes it ineligible for registration as per Section 9. So if we qualify Section 2E's definition is registrable, but then it is limited by Section 29, which lists out various instances where it becomes non-registrable. Again, Section 11 of the GI Act says who can register. So this is pretty easy in the purview that any association of persons or producers or any organization or authority established by law. So an association of persons, producers, an association of producers or organization or authority which is established by law or under any law can apply. So so it's like basically like a group of persons can apply, provided they are representing the interest of the producer and is desirable then and they have a desire to register. Provided these two conditions are being fulfilled, then any a group, it doesn't say about a person per se, but then it talks about a group of people approaching the GI registry to get their indication registered. So the only condition that is required is that they are representing the interest of a particular a group of producers and they have a desire to register it. So say, but say this is more in the sense that if a group of people from Tirur region itself who are non-producers approach the GI registry to register a particular particular GI, then but then they don't have a they are not representing the interest, or they don't have they are not in at most good faith, then that is not they are not eligible for registration. So basically section 11 qualified any group of people who has some kind of interest to protect the interest of the producers, and having a desire to register, can apply before the GI registry for registration. There is another concept in GI which is for us to understand, because it is a relevant concept under the GI Act. So as per the law, a group of people who has a desire and who has the interest of producer can approach the registry. But then who's able to use this registry, this particular indication? When we're talking in the last class, we were talking about the difference between trademark and GI. So specifically here, when we look into the concept, it is being registered as a community's property. So a particular community from a particular area who's producing this particular GI is given they are given a special authorization to use it. So how can you become a member? How can you use these particular GI is a question. So the Act has introduced a concept called authorized user, wherein whoever desires to use a particular GI, but then they are provided that they are producers of the goods. So I am from a particular area. I am producing the say for example, let's take an example of Aranmula Kannadi. So I am from that particular area of Alappuzha district, and I'm producing. My family has been producing this Aranmula Kannadi for a long period of time, and I wanted to continue with these use, and I want to get the GI. I want to use the GI tag in my products. So what I have to do is that I have to be an authorized user to use this particular tag. GI has already gotten registration under the GI Act, and the Aranmula Kannadi has already gotten registration under GI Act. So I have to get registered under the GI to use it. So I would be the authorized user. So section 17 talks about authorized user. This is any person who is claiming to the producer of goods in which this particular GI has been granted. All he have to do is that he have to submit a written request to the registry, and the registrar would inquire about his whereabouts, and whether it is a on whether he is so we were talking about authorized user concepts under GI as per section 17. So the section specifically talks about a person who has the right to use this GI tag. So when we looked into the act, we looked into what constitute a GI, and a GI basically gives someone a right to use a tag saying that this is a geographical indication and it has all these qualities. So if I am from the specific region, then I have to make an application under section 17 to make sure that I am being an authorized user and I can legally use these marks. Again, the term of protection for GI under the Act is for 10 years, which can be renewed from time to time. It is not something. This is again a difference. There is again a difference between other types of IP and GI, including biodiversity, GI, plant varieties, and all. Wherein other types of IP, including patents, copyright, trademark, has a specific set of ending point or duration, owing to the public welfare concept ingrained into the protection of ingrained to the in principle of protection of IP laws. But in GI specifically, we don't have an end date. So it goes in perpetuity until unless and until it keeps. If you are able to renew it for a period of time, then it keeps going on. Specifically it says that you initially it's been granted for 10 years, and every 10 years you are eligible to renew it. That is again a key marking difference between other IP laws and geographical indicators. Okay. The process, the procedure for granting GI in India can be seen. I'm sure I've shared your screens. So this is a very flow chart where you can see this. So you file an application, and the examiner whom you who looks into the application will examine this. They might ask to submit. They might advertise it, and they might object. They might object. Maybe some of the forms are not filled, or if it is not, if it says, say, if it is not registrable under the act itself, then the registrar, the examiner itself would raise objection. And after hearing opportune, obviously we need to give opportunity to be heard. After hearing, either if it is they are refusing, then it goes to IPAB. IPAB is the board established under section 83 of Trademark Act, intellectual property appellate board. It's called Intellectual Property Appellate Board, which is established under Section 83 of Trademarks Act. നമ്മുടെ GI Act Section 2A has defined that all the appellate board body under the GI Act would be IPAB. So it's a circle. The GI Act says that as per Section 2A of GI Act says that the appellate authority is IPAB. IPAB is again defined under Section 83 of Trademark Act, and they would look into the whether the objection is standing or not, and it stands with the IPAB. If it's been accepted, then they are going to advertise it in the GI journal. We have a similar journal for the Plant Varieties Act also, which we look into when we are discussing about the Plant Varieties Act specifically. And when there is an opposition, again they will be they would have they would be allowed to they would be looking into this opposition. People are allowed to comment whether it has there is an existing GI, or this is not a true GI. So if there is there is some kind of opposition, then it can again, if the examiner would again examine it, and if there is some kind of crux, or there is some kind of matter in the opposition, then they would deny it, which can be appealed to the IPAB. If it is not, then it is accepted as GI and is registered in the GI registry. So the procedure completes when we have entering this particular GI in the GI registry, and a certificate being issued. Okay, so this is especially what is happening. So there is this particular registry has two parts, Part A and Part B. Part A is regarding what are the what specifically is the GI. GI if say for example, the Adamula Kannadi, Kutambuli Sari and all are GIs, relevant GIs. So that they would be those names would be entered under Part A, and under Part B of the registry, they'll include the authorized user who can use this particular GI. So the authorized user would be in Part B, and Part A would contain what are the various GIs. So this is basically a granting procedure. This is not that important in your net preparations, but it is good to know about the certificates and the registry which has Part A and Part B. These are likely questions that can be asked, given the nature of UGC net currently. All right. So we have looked into what a GI constitute. We have looked into what are the various components that would not be registered as GI. We have looked into the concept of authorized user and the duration of registration. Now let's look into the what is what rights are being granted once we have GI. specifically there are only unlike other IP laws, the rights are very say it's basically allowing authorized users to have exclusive use and preventing others from infringing it. So this is very simple rights, saying that if you are an authorized user under the GI Act, then you have the exclusive right. Only you have the exclusive right to use it. And if someone infringes it, then they have the right to obtain relief in respect of infringement. So these are the basic two rights. Unlike in the other so-called other hard IP laws, I quote unquote, it's hard as on quote unquote. So again, there is this substantial difference. There are a lot of economical rights, moral rights associated with our other IP laws, but here it's very simple. If you have a GI, if you are an authorized user, then you have exclusive right to use it. And if you are not, they would be a suit for infringement. So basically, the rights are very simple. It is defined under Section 21 of the GI Act. These section codes are important, especially in concepts of your net examinations. There is another relevant provision under section under GI Act is section 25, which says that we cannot register a GI as a trademark. So if you are trying to have a GI, then you cannot register this particular GI as a trademark. The trademark is having a different concept, wherein it is specifically exclusive to a particular person or a particular community, I mean, a particular business venture. So it is very individualistic in that nature. But GI is a more a community right. So you trying to protect your GI as a trademark would have a counter effect on the principles and on the objectives of GIs. So these are the basic provisions under the Act. Okay, so I hope that's clear. We have a section 2E where the GI is being defined. Then we have the concepts of what is not being allowed to register, it is being to register. Then we have the process of granting registration, and then we have this concept of rights as associated, duration, and authorized user. And here this section 25 also. For you, for the net preparation angle, it is more important to have a understanding of these sections and what it means. It might, they might ask, I have seen some questions where they specifically ask on these sections, and maybe a definition clause wherein they list out what are the various materials that can be covered. Some of the major GIs that we have here is this is a from a very bird's eye view of the various GI registered in India. Um, uh, this is especially true when when we know that there are around 420 registered varieties in India. So we have 420 GIs registered here in India. And this is as per the DPIIT, Director or the Department of Promotion of Industrial and Internal Trades, where they have given a number, say they have 420 registered GIs in India. Some of them, only 10 of them have listed. It's Kashmiri, saffron, Roshagulla. Roshagulla has a very interesting case, whether this Roshagulla has a origin or a Bengali origin. I think LJRF study material has discussed this particular issue. It would be interesting for you to look into this material also. Then there is this Panjamridam. We are maybe familiar with this concept of Panjamridam. Then Tirur beetle leaf. I have already talked about Tirur beetle leaf. Then this particular technique of Madhubani paintings, Feni, particular alcohol from Goan region. Then Zari crafts are very handicrafts from the Surat region. Then there is Pokali Matta rice, which is basically from the salt water. Pokali rice has a very. I have a personal connection with Pokali rice, saying that the institution I studied was involved in the registration of Pokali's Pokali rice. It's basically from the Ernakulam region, where they have Kadamakudi regions of Ernakulam, where they grow this Pokali rice. But then it's currently there is some kind of there is no enough producers, and all some issues are going on. That one of my senior at IUC IPRS KSAT has done his PhD on this particular area. Then there is Palakkad Matta rice, which is we are again familiar with. I was talking about Aramula Kannadi. Aramula Kannadi is the first product from Kerala which has received which is received a GI tag in 2005. I think Darjeeling tea or something was the first one that received GI tag in India. I'm not sure. It's subject to verifications. So basically, these are the major GIs. Let's look. These are the basic GIs that has been registered in India. Again, I said there are about 420. These statistics are available in the DPIIT's site, and anyone can verify it. So we have now looked into the concept of GI. Let's look into what is the difference between GI and trademark. A trademark is specifically to distinguish, is used by an enterprise, individual or a company, to distinguish its products of service from other enterprise. So it is for making sure that I have produced it and not them. Here, it is to tell the consumer that this has a particular place of origin. So this the first difference is basically, one talks about a particular company producing it, and here it talks about comes from a particular region or a place. The origin is the key concept in GI. While in trademark it's specifically an enterprise or company that is being having a concern. Here, the trademark gives an exclusive right to the owner of the trademark to use it. Here in GI, all authorized users and all producers can use their GI. So, in a very larger sense, a trademark relies on the more individualistic perspective, while a GI has a more community concept, community use in mind. So that exactly is a core diaspora between the trademarks and GI. It is good for us to understand what makes one different from the other. So basically, this is all what we have to look into the GI Act. If you have any queries, you can ask. Um, these I know this is it is also, let me mention to few facts. I understand this is a big act. I know a few of my colleagues who are already working on GI for their research. It is not easy enough to it is not small enough for me to cover it in an hour, but then our purpose is different from the other researchers or other students of interest. So for the preview of for a net exam, let's stop it here. To read more on this particular topic, kindly check out LJRF's notes, which is available on our LMS platform.
Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is, I think, is a constitutional